let's talk about broken promises. Specifically, what happens when a promise is broken, but just getting some money back doesn't feel like justice. Today, we're diving into a really fascinating area of Indian law, the Specific Relief Act. Think of it as a special toolbox for courts designed to deliver what was actually promised, not just a payout. So let's open it up and see what's inside.
I mean, really think about this for a second. You finally find your absolute dream house. You sign all the papers, and then the seller just backs out. Or maybe you hire a one-of-a-kind artist to paint a portrait, and they just don't. Would a check for the damages truly make that right? No way. Sometimes you don't want the compensation. You want the house. You want the painting. You want the thing you were promised. So, what can the law actually do in those moments?
Well, that is exactly where this act comes into play. You can really think of the Specific Relief Act of 1963 as a judge's special toolbox. When plain old money damages just aren't going to cut it, they can reach into this box for some very specific tools that enforce promises and stop problems in a much more direct, hands-on way.
Okay, so let's pull out the first and maybe the most powerful tool in the whole box. I like to call this one the promise enforcer. It's the one that basically says, hey, a deal is a deal. You signed it, you're going to stick to it. It's all about making someone keep their word, exactly as it was written down.
And the official name for this is specific performance. It is not about getting a payout for your trouble. Nope. It is a direct order from a judge, forcing someone to do the exact thing they agreed to do, hand over those house keys, finish that painting. It's about getting what you were actually promised from the get-go.
So who can the court actually use this tool on? Well, it starts with the person who signed the contract, obviously. And here's where it gets really interesting. Its reach can go further. It can extend to someone who bought the property after you did, but only if they knew about your original deal. It can even apply to a brand new company that was formed by merging with the old one. The law is pretty smart. It's designed to stop people from just shuffling things around to get out of their responsibilities.
All right, let's grab the next set of tools from our kit. What if the problem isn't that someone broke a good promise, but that the promise itself was, well, bad from the very beginning, flawed? For situations like that, the court has something that works a lot like undo and cancel buttons.
Now these two, rescission and cancellation, they sound kind of similar, but they do totally different jobs. Look here. Rescission is like hitting the big undo button on the entire deal. It treats the contract like it never even existed. Cancellation, on the other hand, is more like taking a specific harmful document and running it through a shredder to make sure it can never, ever be used against you. One voids the whole agreement, the other just voids the piece of paper.
Right, so with rescission, the court pretty much rewinds time. If you are tricked into signing a contract because of, say, fraud or some major lie, a judge can just rescind it. This means everybody has to give back whatever they got out of the deal. It's a complete and total reset.
And cancellation? That's for when a specific written document, like a forged deed to your property, is just hanging over your head causing problems. You can go to court and ask a judge to officially declare it void and order it canceled. That way, nobody can ever use that piece of paper to cause you trouble again.
Next up, we've got some of the most direct and forceful tools in the entire toolbox, the court's power to issue commands. These are called injunctions, and they're basically the court's stop-and-go orders to take immediate control of a situation.
And this little chart illustrates the two main types perfectly. You've got the temporary injunction, which is pretty much the court's pause button. It freezes everything in place while the case is being sorted out just to make sure no more harm is done. Then you've got the perpetual injunction. That's the full stop. It's a final permanent order that's issued at the very end of a case, and yeah, it can last forever.
But a judge doesn't just hit that pause button for fun. To get a temporary injunction, you have to prove three key things. These are the three golden rules right here. First, you've got to show that you have a real arguable case. Second, you have to prove that you'll suffer some kind of harm that money just can't fix if the judge doesn't step in. And third, you have to convince the judge that fairness is on your side, that stopping the action will cause less harm than letting it continue.
And it's not all about stop signs either. The court can also issue a go order. That's called a mandatory injunction. For example, if your neighbor builds a wall that illegally blocks your driveway, the court can issue a mandatory injunction forcing them to tear it down. It makes them actively undo the wrong.
Now for a very different kind of tool, sometimes you don't need the court to force anyone to do anything or stop doing anything. You just need an official, legally binding clarification. You just need the court to state a fact, once and for all, to put an end to an argument. This is called a declaratory decree.
It's basically a formal announcement from the court that clarifies your legal status or your right to a piece of property. It doesn't order anyone to pay up or take any action. It just provides a solid, binding legal truth to stop future fights before they can even start.
So to get one of these, you have to show that you're entitled to a specific legal right and that someone else is denying it. But, and this is a really important catch, the law says that if you're in a position to ask for more, like not just a declaration that you own the property, but also for the court to grant you possession of it, you have to ask for the whole shebang at once. You can't come back later for a second bite at the apple.
So we've looked at some incredibly powerful tools in this legal kit: forcing promises, erasing bad deals, issuing commands, and declaring truths. But there's one final, absolutely crucial element that controls how all of these are used, and it's this: none of these remedies are automatic.
This legal quote really says it all. The key word here is discretionary. In simple terms, this means that just because it's legal for a court to grant one of these remedies, it doesn't mean it has to. The judge always has the final say, and their job is to weigh the situation and use these powerful tools in a way that is fair and reasonable. So, when might a judge decide to just say no? Well, as you can see from these examples, it all comes down to fairness. A judge might refuse if the contract gave one person a massive, unfair advantage. Or maybe if forcing the deal through would cause some kind of unexpected and extreme hardship that would just ruin the other person. And this one's huge. If the person asking for the court's help has been acting unfairly themselves, the court might just refuse to get involved. It's all about reaching a just result.
You know, this whole legal toolbox forces us to grapple with a really fundamental question. If a contract is a promise, what does real justice look like when it's broken? Is it enough to just compensate the person for their loss with a check? Or, as the Specific Relief Act suggests, is the only true justice found in making someone actually keep their word? The answer to that really defines the very nature of a promise itself. It's something to think about, isn't it?